Do you have a child with a disability coming up on their 18th birthday? And on top of planning this really big birthday party, now you have to also plan for what it means now that your child is turning into an adult. Do you seek guardianship, conservatorship, power of attorney? And while I'm no attorney, I can give you an answer just like one. It depends. Now in this video, we're going to be talking about the differences between these three so that you can feel well informed when you go in to make that really important decision. Hi, my name is Elizabeth, and for all the best information on special needs planning, make sure that you hit that subscribe button and the notification bell to make sure that you're alerted every time that I post new videos. Okay, so first let's talk about what a guardianship is. A guardian is somebody who looks after somebody who can't take care of themselves. This could be incapacitated person, a person with a disability, or a child whose parents are no longer able to take care of them or have passed away. Now, normally a parent is the guardian of a child until that child's 18th birthday. That means that before they're 18, they can make decisions for their child and their authority isn't questioned by doctors, dentists, and school personnel. But once that child turns 18, the parent's authority ceases. Now the child is able to make all their decisions on their own, and the parent doesn't get a say. If the doctor doesn't feel comfortable talking to them, then they don't get to. Often a parent of a child with a disability will petition the court for guardianship of their child, and normally that petition is granted. But there are some cases, like if the parents don't live together and can't agree on who the guardian should be, where the court has to appoint an independent guardian, somebody that isn't one of the parents. Now, before this happens, it's a really good idea to get a mediator involved to help the parents really agree on who the guardian should be so that they don't have to have a contested hearing where an independent guardian is appointed. So for those parents who are seeking guardianship, it's really important that they also take the steps to name successor guardians in the case that the parents actually pass away and somebody else has to take on those caregiver responsibilities. Now, while a guardian takes care of the medical and residency affairs, a conservator takes care of the financial affairs, things like what to do with a person's property and their assets. Now, a guardian can also serve as a conservator, or the two roles can be divvied up. A conservatorship requires a lot of maintenance. You need to be able to keep really good records of all receipts so that you can account for the child's funds to the penny. For some people, having an appointed guardian and conservator is a really good option, and for some it's not. Let's take Britney Spears, for example. Now, over a decade ago, she entered into a conservatorship with her father after her very public breakdown, and while it was only supposed to be for a limited amount of time, it has been extended years and years and years. Now, this happens to be an unusual case because a conservatorship is supposed to be for people who are not able to take care of themselves, but Britney Spears has been working nonstop throughout the entire conservatorship. This just goes to show that it's important that people understand how the conservatorship and guardianship really infringe on the independence and rights of the person under the guardianship. Because these involve such a profound loss of freedom and dignity, state laws require that before a guardianship is appointed, less restrictive alternatives have to be tried and failed prior to appointing the guardianship. So one of these alternatives is the power of attorney. And a power of attorney is granted by that person to somebody that they trust. It is not imposed upon them like the guardianship and conservatorship are. For instance, a person with autism who decides they can't manage their assets on their own could appoint somebody could grant somebody the durable power of attorney so that they can manage their assets on their behalf. Also, a healthcare power of attorney could be created so that somebody else can make healthcare decisions for them should that person become incapacitated. Actually, it's a really good idea to get that done for anybody. The appointment of a power of attorney is a private affair. So as long as the adult child can demonstrate sufficient capacity, then they would be able to execute the two powers of attorney with very minimal court involvement. So when you're deciding on whether a guardianship, conservatorship, or power of attorney would be most appropriate, it's important to consider your child's mental capacity, their ability to manage their own affairs, whether that be residency, financial, or health. And then also you need to understand the limitations that a conservatorship and guardianship put on your child. I hope that you found this information to be helpful. And while there are, some basics when it comes to special needs planning, it's really important to speak to somebody who has specialized knowledge in the area of special needs planning for your individual approach. Now, if you like this information, make sure that you hit that subscribe button and the notification bell to make sure that you're alerted every time that I post new videos, and please share it with a friend. And if you really liked what you watched today, make sure that you click on that link below to become a client so we can start coordinating your overall financial strategy with your special needs plan. Because remember, planning for your loved one's future today makes for a confident tomorrow.